Welcome and hello. Welcome to the Go Plan video library that includes Greenleaf Financial Fitness Series and other financial professional series involved with personal financial wellness. This series, along with other videos, will be posted on our Go Plan YouTube channel, websites, and other social media outlets. My name is Jim Hiles, and as your host, I think it's important to highlight what financial wellness is and how tools like Go Plan 101 can help Americans achieve their goals and wishes. So, what is financial wellness? It is defined as the overall financial health of an individual. What it does for you is probably most important. It helps you increase understanding all things related to money. It can also help decrease stress, help you make better decisions, and perhaps most importantly, keep you on track as things change in the future. What's Go Plan 101? Well, Go Plan 101 combines web technology and educational content with behavioral change solutions, free software, and a huge resource center full of focused responses. Translation? Simple. Go Plan 101 is a cool site that helps people deal with their money issues so they can do what they want to do. And you also have the capability on our site to talk to a coach or go right to the resource. At the end of the day, financial wellness is only as good as the actions taken. So sit back, relax, and enjoy the video.
Good afternoon and welcome to the Greenleaf Financial Fitness Series, 20 minutes to a healthier, wealthier you. In today's installment, which is powered by First Capital Advisors as always, we'll be discussing estate planning. We'll be covering a lot of ground, so remember that you'll be able to refer back to the recording later if you need to. As always, I'd like to just make some quick introductions to the people who make these webinars possible. We have Jamie Greenleaf, partner and lead advisor at Cafaro Greenleaf. Jim Hiles, here with me, is a senior partner with Greenleaf and managing partner of First Capital Advisors Group. I'm Jim D., financial advisor with Greenleaf, also a wealth advisor with First Capital. So if we're going to talk about estate planning, first let's define the term. We believe that it's a process, not a one-time event. So the first thing we want to do when it comes to estate planning is identify the goals. Define what you want to accomplish. And then next, what we do is we get together all of the pertinent information. We call this gathering the data, assets, liabilities, family members, and so on. Then we discuss what we see as potential obstacles to achieving our goals, what planning opportunities that we see to help address them. Then, of course, we need to implement the plan and periodically review or make changes or adjustments that are needed along the way. So, Jim Hiles, you've spent a good part of your career teaching and learning about the ins and outs of estate planning as the National Director of Estate and Trust Services for a large Wall Street bank. Why don't you start here and tell us a little bit about the importance of asset titling?
Sure. Thanks, everyone, and good afternoon. So estate planning has to do with your estate. Well, to know what your estate is, you have to be able to identify what you own. And when you talk about what you own, you may own things in different ways, and that's what you call asset titling. The most simple way, it's literally called fee simple, is you own it. Fee simple means you have absolute unencumbered control over a piece of property. And by the way, the term property doesn't necessarily mean just real estate property. It can mean any physical, tangible property or even intangible property. Intangible property might be a mutual fund, a stock certificate, something like that. So we're talking about all of the things that you own, all of the things that are called assets have some sort of title on them, whether you know that or not. When you're doing estate planning, if you're trying to direct your assets from one place to the next, you want to make sure you understand how it's titled today. And let me give you an example. If you own it fee simple, that means you own it. You control it. It's yours. However, when you start getting into joint owners, like tenants in common, tenants in common is a term where two or more people own a piece of property, and they have certain rights, and they have actually individual and separate rights or interests in the property. So when you look at it from a tenants in common standpoint, this TIC, if you see that on something, you know that there's at least two people, and they can decide what they want to do with their own interest. So you can have more than two people on it, and then it gets a lot of fun when one person says, I want to deliver it to this person. Another one says, I want to deliver my share to somebody else. So tenants in common is a way you can do sort of a partnership on an asset and let everyone control what happens to the disposition of it. Now, here's the first thing we get to in many situations. I own it, joint tenants. And a lot of people confuse tenants in common with joint tenants. Joint tenants is that you have two tenants generally jointly owning a piece of property. However, if it says rights of survivorship, then the survivor automatically ends up with the property. So if two people own it, husband and wife typically, joint tenants with rights of survivorship, and oftentimes you see it as JTWROS, rights of survivorship, no matter what happens, no matter what your will says, operation of title, joint title, right of survivorship, is the controlling feature, not your will. So if you own things joint title, right of survivorship, and you have a will, it's not necessarily going to go through the will document. It's going to go a la property titling.
That's important to know that it supersedes the will, right? So here we see some more ways assets can be titled. Payable on death, or POD. That type of titling is available for most bank accounts, brokerage accounts, mutual funds, which what a POD account does is it names a designated successor owner for an individually owned asset. And those assets pass directly to the successor owner outside of probate. It's also sometimes called transfer on death accounts. You may see it titled as that. Next, we have UTMA or UGMA, Universal Transfer or Gift to Minors Acts. Depends on what state you're in. Different states use one or the other. This is a lifetime transfer of assets to a minor, with assets managed typically by an adult custodian until the minor reaches the age of majority. Full ownership, when you gift it this way, is immediately vested in the minor. And
let me just raise a little point here. We have we're going to talk about estate planning, but there's lifetime planning and estate planning are tied together. So one of the things we often see is even UTMA or custodial accounts with your kid, and when they become 18, generally it's 18 or maybe 21, that's age of majority, they get the money. It's their money. It's their asset. So make sure when you're looking at even titling your assets during your lifetime, you're aware of these features of these asset titling.
Good point, right? And we also have 529 college savings accounts, where in these accounts, the assets grow tax deferred and withdrawals are tax free as long as they're used for a qualified higher education expense, which is defined by law. The account owner can change the beneficiary with some restrictions, but the owner is not necessarily the person who's going to use it for college, right? So the owner can change that person. And any account growth that's not utilized for college and withdrawn subsequently is subject to taxation and a 10% IRS penalty.
So we're talking about different things which can transfer directly to somebody else without a will. So we've talked about TIC, joint titles, right of survivorship, TOD and POD accounts, these uniform gift to minors accounts, 529 plans. All of these are going via some sort of way outside a will directly to somebody else. Let's talk about the next slide.
Right, so that's titling. So after titling, let's look at beneficiary designations. And I'm sure the people on this webinar are very familiar with the importance of taking care of your beneficiary designations, because I know how much most of the HR people out there on this call stress it to the employees. So please make sure your beneficiary information is up to date. Passing wealth through a beneficiary designation is typically available on accounts with a contract beneficiary, an employer-sponsored retirement account with a named beneficiary. Same with individual retirement accounts, IRAs, life insurance contracts, annuity contracts. They all ask for a named beneficiary when you open them. When designating beneficiaries, remember to include not just your primary, but contingent and successor beneficiaries. That's important. And Jim, we've had some experiences with special considerations for IRA contracts. You want to talk a little bit about how do we extend IRAs?
Yeah, sure. So when somebody passes on, it's possible to designate an IRA to the beneficiary, and the IRA itself can retain its tax deferred features of being what we call an inherited IRA or decedent's IRA. So if if my mom passes away and she has an IRA of which I'm a beneficiary, I could keep it within an IRA. I'm the beneficiary of it, so it'll come to me. But I don't have to take all the money out. I could let that accrue over my lifetime and hopefully get some tax advantages from that.
Right. The rules are a little different depending on whether that owner was over age 70 and a half or under. But
so let's talk about taxes. And this is the thing we hear about a lot. Death taxes. Well, this is kind of funny. It's been in the news a lot. There's no such thing as a death tax. It's actually was kind of made up by, I'm not even sure who.
Political term.
Yeah, it's a political term. So let's have some fun with it anyway, right? So what we really have is we have estate taxes. So estate taxes are due when somebody dies. So this is probably what one of the death taxes was about. But there actually is a better name for it. It's called federal estate taxes. Right now, under current law, a person is allowed to transfer $11.2 million without paying an estate tax. So husband and wife together, $22 million before you have to worry about federal estate taxes. Over that, however, you're paying 40% of that back to the government. So you got to be careful about estate taxes. Most individuals are going to be exempt from having to pay them at this point. However, watch out for the state. The state has its own estate tax or state inheritance tax. You got to be careful it depends on the state you pass away in. So you may have an exemption there, or you may have to pay a tax there. Income taxes, just because you die doesn't mean you get out of paying your income taxes. In other words, these IRAs we talked about before, if you haven't paid taxes on it during somebody's lifetime, you're going to pay income taxes on it over the beneficiary's lifetime for sure. And the last thing, which they kind of throw you a bone here a little bit, is in your estate, if you died and you owned a piece of property, let's say that you bought it for $10,000 and it's worth $100,000. At your date of death, you get what's called a step up in your basis. In other words, your beneficiaries can sell that asset and not pay capital gain tax on the asset after they inherited it.
One of the few tax breaks still out there, right?
One of the few tax breaks you still get. You have to die to get it.
Somebody's getting it. So let's look at the basic documents now, starting with a basic will. Basically, it is a formal expression of wishes regarding the disposition of assets. It is effective only upon death. We'll address living wills a little bit later. So you may change provisions in your will as long as you're still alive and as long as you're still competent. And in it, in a will, you nominate an executor to implement the will's provisions, and you should identify your choice of a guardian if you have any minor children. As far as probate considerations, probate is basically the process of proving the will, and it's the executor's job to settle the estate. So if you don't have a will, it's considered dying without a will is considered intestacy, right? So in that case, it becomes, if you think settling an estate is a hassle with a will, try it without one. Your plans and desires are really not considered. It's basically your estate is settled via a state mandated program. And here there is very strict regulation, interpretation of the hierarchy of inheritance without any regard to what your individual, what any of your survivors' individual need or circumstance may be. It's an executor is chosen and appointed by the probate court. And as far as any guardianship issues go for any minor children, those are also decided by the court. So it's strictly a by the book, blind justice type situation. So it's a good idea to have a will. More basic documents. Let's look at powers of attorney, or POAs. Right? These are the basic types. We have a general power of attorney, which is a written document that allows one person who is the attorney in fact or the agent to act on behalf of another person during the principal's lifetime. There's two different kinds. It could be limited or it could be general. And it's either way, it's only valid when the principal has the legal capacity. I.e. is not disabled or mentally incompetent or under some other type of incapacity. Next, we have the durable power of attorney, and this is the power that should really be used for proper estate planning because it allows the POA to continue in the event that the principal becomes ill or incapacitated, and it's unaffected by any subsequent disability or incapacity of the principal.
Yeah, let me try to knock it down to why you need one of these things. And we often talk about longevity and people living longer, and we also talk a lot about long-term care and people who need help. And one of the things that you're going to have to figure out is who is the person that you want to designate for the person to maybe help you write your bills or takes care of your taxes or take care of the house or make sure your medical bills are being paid, or even vouch for you and those kinds of things. So the durable power of attorney basically allows you to appoint somebody to act on your behalf. And that's one of the things you look for. Now, can you abuse it? Yes, there have been stories where we have some dangers where somebody takes advantage of somebody else. Unfortunately, that's hard to control, but if you choose wisely, unlikely to happen to you in terms of, because you have to do it. At some point, you're going to have to do this where you give somebody else control over your affairs. And often it's going to fall on the shoulders of family members. There's something called a springing power, which is basically says when some event happens, this power springs into action. So you can write it so that if I am incapacitated and unable to speak or something to that effect, then this springs into power and someone is allowed to go ahead and have the power of attorney over my affairs. So you can actually use different ways to engage the power of attorney. So you should have powers of attorneys with your estate plan. You should have a will. You should understand your assets, how they're titled. But you should also look at do the things which I hear a lot of confusion about, what's a living will? A living will is not what we've been talking about. A living will is more along the lines of life-threatening or end-of-life questions or the answers to them. And the proper language is really something called an advance directive. And this is where you give individuals the authority to decide what kind of health care that you want to receive. And these are decisions that you can think out during your lifetime. So when the event happens, then there's no question as to the type of quality of health care that you're going to receive. Or if you have a situation where you're in a situation where you just can't get out of it and it's a matter of just time, then somebody does need to make the decision to end life. And that's what an advanced healthcare directive is. And you should have these documents put aside now. In fact, if you go to a hospital, you should bring one with you or have one sent in because they'll often ask for them if you've had that experience already.
Very good. So now we're going to look at trusts. So trusts in general are fiduciary relationships in which a trustee, one person, holds title to a property placed in the trust by a grantor, someone who owned the property, for the benefit of a beneficiary. There's a few different kinds. We have an irrevocable trust, which is permanent. That can't be revoked or changed. Once the assets are placed in the trust, they are permanently relinquished by the grantor. We have a revocable trust, which can be revoked or changed during the grantor's lifetime, and a testamentary trust, which is really a testamentary trust is basically, it's not created until it's created in the will. So when the person dies, that's when the trust is actually created, when the grantor of the trust dies.
Yeah, let's talk about trust just from what it really means. So we've talked about kind of what they are here, but do you need one? Do I need a trust? I get the question a lot.
That's a question, right?
Yeah. So the answer is it depends. If you have a good will and you've set up your asset titling, you understand how your will flows. We're going to talk about flow chart in a minute. You may not necessarily need one. Where a trust comes into play is if you have beneficiaries who may not be able to handle the funds in such a way where you feel comfortable, and you want to make sure that somebody that you deem maybe more responsible, more capable to manage assets for somebody else, then you might consider having a trust put together to handle those assets for the beneficiaries. Oftentimes you'll see this in some fairly simple things, like if a beneficiary is a special needs child and they can't perhaps manage their finances and they need help, then a trust like this is a perfect fit to take advantage of what's happening in trust law to make sure that child is going to be taken care of in the right, prudent way. Whether or not it's revocable or irrevocable is really a decision that it's what it sounds like. Irrevocable means you can't change it. So when you put something in a trust irrevocably, you are putting it in there forever. It's out of your hands. It's out of your estate. It's not part of your deal anymore. So beware of that. So the alternative to that is to set up what's called a revocable living trust. Now, let's not get confused. This is not a living will. This is a document that really came to being a few, maybe decades ago. It became more popular because what the revocable living trust does, it allows the individual to set up a trustee for themselves. So if something happens to you, it's already in the place you want it to go. It's a revocable living trust. They're extremely flexible. You can put assets in, you can take them out, you control the assets. And the reason we like them is because generally revocable living trusts avoid probate. They're already where they're supposed to go. So you don't have to have anyone process them from point A to point B. They're already sort of in point B. So we like revocable living trusts. Think of this as an add-on to a will. You might say, I have a will, that works fine, and I would agree with you. If you're interested in avoiding probate, you want to set up a revocable living trust, and there's some pros and cons to this. So when you do pros and cons, a revocable living trust allows you to potentially avoid issues in probate and keep things more private and make it much clearer as to what your intent is. However, you've got to set it up. So you have to pay for an attorney to set up a trust. You have to retitle the assets into it. And, it's relatively secret. You should still have a will with it. Don't say that the trust is replacing the will. You should have what's called a pour over will that basically says if I don't put all my stuff in my trust during my lifetime, a pour over will scoop it all up and throw it in there before I die.
Okay, let's talk about the flow chart you mentioned earlier, right?
Yeah, I mean, this is so let's think pragmatically about this. Let's go back to the beginning where we started. So what do I have? And lay it out on a piece of paper and say, well, because each of these assets, and let's look at them for a moment. You've got IRAs, annuities, and retirement plans. And what do we know about them passing through an estate? They go by beneficiary, not by your will, not by a trust, right? So you got to make sure you line up your beneficiaries with your will and your trust. And then other things you want to do. Your life insurance, same thing. The beneficiary designations are very important in terms of what's going to happen to the life insurance benefit. The joint assets, well, we talked about the different kinds of joint assets in terms of how they are titled. Joint assets, tenants in common, which means that each person has a piece to direct any way they want. That's going through a will. That has to go through a will. It doesn't go to anybody, so somebody needs to say, where does this go? Well, that's what a tenants in common does. However, a joint title with rights of survivorship goes automatically to the survivor. It does not go through the will. That could be a problem if that's not what you want to have happen to that asset. Of course, what you own has to go someplace. So your will is going to direct what you own individually. And in terms of other insurances that you might have, long-term care, for example, might go to beneficiaries to receive long-term care benefits. If there's any type of cash available to it, then you have to figure out where it goes. Oftentimes the questions are, if my spouse is still alive, I want to get it to them, or if I don't, then what are my other choices? Kids, charity, grandkids, other heirs, other charities. Keep in mind that the government is out here, and that's one of the things we try not to do, is make sure our inheritance ends up in the hands of the government or the probate court. That's part of the process of estate planning, is just figuring out where your assets are today and where they're going to end up. And do this little flow chart, and you'll kind of guide what you think, what your thoughts are, and then sit with somebody to go through and put together the estate planning documents you need.
Very good. Okay, we covered a lot of ground in a little more than 20 minutes. So let's sum it up. To get started, first thing you should do is list out your assets, then review each of those assets for titling and beneficiary designations. Make sure that's buttoned up. Think through what you want and how you want your assets to be passed on, and then have your estate flow chart that we just saw, or a roadmap in terms of how you want those assets to flow through. Create or update your will, and review the various types of POAs and healthcare proxies. If you have a will or a trust and you're not sure it's appropriate for your situation, give us a call. We have a lot of experience, as you heard earlier, in this area. We can help you.
Let me just interrupt on that one note, because typically I would prefer that an attorney who knows what they're doing, whether it's with estate planning or trust services or elder law, is involved, because we are not attorneys to draft documents. However, to the extent that you can do a lot of this legwork, you're going to find that the experience goes a lot smoother when working with an attorney. So we covered a lot of ground, and let's just summarize. It's time to put this information to work. We live in a wonderful and a free country, but it's up to us to take responsibility and move forward, particularly on our personal financial wellness. So let's take some action here. Let's go and explore this financial stuff. Take a buddy with you if you need to. Have some fun. Learn a little or learn a lot about what you can do financially. These videos and websites, I hope you enjoy. I think they're great. But if you're like me, sometimes you just want someone to talk it out with. So seek out coaching from our site from professionals who've been vetted to provide you with complimentary initial consultations as being part of the Go Plan 101 experience. If you've not started your planning, or even if you have, use today's video to explore the area of concentration. Make sure you understand how it impacts you. My favorite quote is, life doesn't go in a straight line. You need to stay on top of it. So consider subscribing to our newsletter or our YouTube channel. Please reach out to me if you want more help or have questions. And lastly, thank you for listening. Now, go plan and go attain your financial wellness goals. Jim Hiles signing off for today. Take care.